So my topic today is a few of the funnier cases that have come out of family provision in the last 18 months or so. And as estate planning lawyers, one of the big things that we get asked is kind of what's the point of even doing my will anymore? No one really cares what I've written down in my document, they're just going to challenge it anyway. That's a hard question to answer, but we'll look at how the courts have dealt with some of these challenges anyway. So the first one is actually one of my favourites that has come up in the last 18 months. Did anyone see this article down in Sydney of the homeless man who claimed against someone's estate? We've got a couple of nods here, that's good. He literally was homeless at the time. In his court documents he said, "I was living in a tent." So obviously he had no money, he had no assets, he had quite a few debts, gambling debts, as you can imagine. And he was in quite a bit of need. Now this lady wasn't his spouse, he wasn't her son, but he was making a claim nonetheless, and the basis of his claim was as a dependent. And there's some strict rules around it, but he was basically saying, I've been caring for her for the last few years of her life. I took her to all of her medical appointments. I looked after her on a day-to-day basis. Sometimes we lived together, sometimes we didn't, but nonetheless, I was dependent on her and she was dependent on me, so therefore I should get a chunk of her estate. Different situation, she didn't actually have a will, so she was going to die intestate, and as I said, she didn't have any kids or any spouses or anything like that, so in this situation all of it was going to go to her brother, and it was a $2 million estate, so we're not talking about, you know, just a property and a 50 grand in a bank account or something like that. $2 million is a fair amount, and obviously the brother wasn't particularly happy at this homeless man coming out of the woodwork. In the first instance, at least, he did actually get half $500,000, which is not bad, really. For they hadn't really known each other for that long. They'd known each other for maybe a couple of years, and before that, 30 years ago, they'd known each other in an interesting capacity that you can see up there on the slides. But he's still got $500,000, and the judge went, you know what? Yeah, you sort of lived together. You helped her out. I'm going to award you this one. The brother anticipated even before the judgment was handed down that he was going to appeal it, and he did, obviously, and he got it overturned. But I just thought it was so fascinating that this person got a quarter of the estate for doing fairly little, actually. The appeal judge said, you hadn't even lived together. You were not living together at the time, you were not dependent. Go away. Luckily he got his cost paid. Oh, sorry, I missed one. Luckily he got his cost paid out of the estate, because otherwise, you know, there's no way he would have handled that. Perhaps it's more surprising that he even found a lawyer in the first place to take him on. The next one is an update on one that Steve's talked about a few years ago. Our favourite secret love child of Michael Wright, the mining magnate over in Western Australia, who was the business partner of Lang Hancock. This is the lemon and mead, or mead and lemon, depending on which level we're at, that you might remember. And this is, I've just put up some of the different things that she was claiming she was going to need in her lifetime. But essentially she was a child from the first relationship, or one of the, a secret relationship rather, and Mr. Wright left most of his estate to his two legitimate, so-called legitimate children of his present marriage, and his estate was worth $1 billion over all various entities, and poor Miss Lemon was going to get 3 out of $1 billion. Now, who would ask for more? Be honest. I probably would, so, you know. And the way that it was structured, she wasn't even really going to get $3 million. Only if she was a good girl and didn't do any drugs and didn't, you know, become a Buddhist or something like that. It was very strange and very restrictive conditions on her even getting any of the $3 million. So she did bring that claim, and the first time around the court said, you know what, yep, you're legitimate. He hadn't looked after you during his lifetime really at all. He hadn't supported her in any way. I think he paid for some private school fees and that was about it. He didn't even buy them a house. or anything like that to live in when he found out that this lady was pregnant. And yeah, so in the first instance, she got 25 rather, and the judge said this is really just a rounding error on the balance sheet of this estate, so it can handle it. Here's your 25, and here's it as a lump sum as well. You don't even have to have it on trust as a restriction. And as succession lawyers, we've been all anticipating quite a bit when this appeal would come down, and it took 2 years, and that's a long time for us. So we're all quite edgy as to what would actually happen, because this was quite a big precedent, the largest provision that had ever been made in a family provision case. And it's not hard to see when you see these sorts of articles come out why people think that it is just a free-for-all. In the end, though, the appeal knocked it down to 6 million. The court said, no, you don't need 25. All you really need is a house, and 6 million is going to get you a pretty good house and some investment income. You'll be right on 6 mil. So he also imposed another trust on top of that. So poor Miss Mead went from getting 25 mil and being able to cover her Pilates lessons for 97 years and $2,300 shoes each year. I wouldn't mind that. To, you know, maybe getting, she'll still get 6, that's still a fair amount of shoes. So, as I said, it sounds like a big number, the 25 mil, but they actually came back to quite a sensible decision in the end. So that's how that one ended up for Mr. Wright's estate. Mind you, the other 2 daughters had 400 million, so I don't think there'll be any appeal from here on in, from their point of view. 6 mil will do. This next one is actually in the courts at the moment. As we speak, it's currently in trial. And again, you might have seen a couple of articles come out, especially in the Courier Mail, it's been in a few times, of Mr. Clasher. He is actually a Brisbane man, so it's quite local for us here. It's a bit difficult to tell at the moment exactly what the facts of this one are and exactly what is going to happen with it, but essentially what we know is Mr. Clasher's got 3 children, obviously, and they're all married and they all have children. At some point in time, there's been some sort of dispute that's arisen and divided the 2 lots of kids. Susan and Wendy, initially, Tom was to have all of his assets divided equally between the kids, and at some point he's changed it so that everything's pretty much going to Janine on the right there. Obviously that's fairly upsetting for Susan and Wendy, and they're currently challenging some transactions that Tom has done to start giving all of his assets over to Janine. And at the moment, there's still questions of whether he actually had capacity to enter those transactions, or whether there was undue influence. Obviously, the 2 on the left are claiming there's undue influence by the one on the right, and the one on the right's claiming that the other 2 were abusing him, and therefore they shouldn't get anything. And whether which one is right or wrong, that's up for the judge. And it's actually in trial in a couple of weeks' time, so hopefully we'll know fairly soon. But the point of this one is this guy's still alive, and they're already disputing over his assets and who should get what. So it's a bit sad from that point of view. And there's all the intricacies of what the other 2 are trying to argue. But the other sad thing that's come up is that there's all these phone conversations recorded of between Tom and the 2 daughters on the left. And he says things like, I can see you recording this conversation. Why are you recording this conversation? And they say, oh, no, we're not recording it. I can see it on your phone. Your phone's sitting there. It's recording me, isn't it? And, that just breaks your heart, doesn't it? And I don't think the judge is going to be particularly impressed seeing that sort of evidence coming up. So we'll see what happens in that one, whether it's whether they're going to undo the transactions. And obviously the issue then becomes if they don't undo it, and the first two daughters have been cut out completely. If there's no estate left because of these transactions, they won't be able to bring a claim because there'll be nothing to claim against if he does die. So obviously from their point of view, it's important that they figure out what has actually happened. And from Janine's point of view, it's obviously in her interest to uphold the transaction. So hopefully when that one comes down, we'll send up an update and we'll see what the end result of that one is. But still a sad one for this old man who's losing capacity, and people are fighting about it when he's even alive, and he's there to see it. So pretty sad. This one, not so sad. This one was kind of always coming, I think. Everyone knows Grundy Media. Yeah. So this is Reg Grundy, who died last year sometime. He only had one kid, one child from a previous relationship and then a new marriage, and they'd been married for, majority of 20, 30 years or whatever. But the first daughter, they'd been estranged since 1994, and they hadn't spoken since then, and it was her choice. He wanted to keep contact, and she said, see you later in 94, don't ever want to speak to you again. His estate, there's still some debate about how much it's worth, but by his own admission in his recent autobiography before he died, he said he was worth 800 mil, so we might as well go with what he said he was worth. Again, if you're getting, and she's getting nothing out of the estate. If you're getting nothing out of an 800 mil, you'd go for it, wouldn't you? The intricacies of this one, and as I've said again we don't have a judgment on it yet. It's still up in the air. He was living in Bermuda when he died. Most of Grundy Media's assets are in Bermuda, and very little was left in New South Wales. So there's going to be some challenge over hopefully bringing some of those assets back into New South Wales to make any sort of claim for her anyway. Mind you, he had looked after her. He still gave her 300 grand every year and paid for first class travel and all sorts of things. So it's not like she got nothing. And she was still to get that sort of arrangement to continue, but she wasn't going to get any sort of lump sum out of the estate. So my gut says this one will probably settle. I don't think Mrs. Grundy wants this being dragged through the media any more than it has so far. She tried to suppress. Even the first case that went through was about whether she had to disclose anything about his assets, and she tried to suppress the decision in that one so it didn't get into the media, and she was not successful in that. So I suspect that she'll do her best to keep this one out of the media from that point of view. But hopefully from my point of view, I can give you a report on what happens in that family provision in the estranged daughter situation that we all love. It hasn't been all bad news for claims against estates. This one was another fun one in Queensland. There's 3 siblings in this one, and 2 of them were cut out of the estate. One is from a different relationship. And initially they put caveats on the estate saying we're going to bring family provision claims, and then they didn't bring it for 10 years. Anyone think they won? No, got kicked out completely. Not because they didn't have need, neither of them really had assets, and no provision had been left for them in the will. But the court said, well, rules is rules, 10 years, there's just no way that we're going to let that one through. And I kind of feel that unless you've been lost in the desert for 10 years, you're probably never going to get it, with that length of time. So that was a fairly good precedent. They have tried to lodge an appeal. I don't think it'll go anywhere. The reason they gave for not bringing the claim was that they couldn't afford the lawyers' fees, which were about 80 grand 10 years ago, and all of a sudden they've now found litigation funding, and the court said, you should have just got the litigation funding back then. Because they could have got up, potentially, so too bad. And then this one that I want to finish on I think is quite a good news story. It's quite a sensible decision, and gives me some hope that the courts are not just completely giving in to every single person who brings a claim. This one is primarily around a mushroom farm. The estate was about 10 or 12 surrounding this farm. And it was run by mum and dad, but the evidence was that mum and dad ran it on the basis that it was essentially owned by them in 5 shares, one for each of mum and dad and the 3 kids. And if you worked in the farm, you'd obviously get your share, and you might get mum and dad's share as well. The first 2 kids had nothing to do with the farm, and the third one did. So obviously mum and dad were more than happy for him to get the extra shares of the estate, and this was an arrangement that was known by not only the family, but by independent people, family friends and such like that. So obviously dad died first, and then mum died, and lo and behold, the third child gets the extra 2 shares. As I said, pretty big estate, so 1/5 each is not insubstantial when we're talking here, but they were disappointed that the third child was getting more than them. And the court was not particularly happy with them bringing this claim. They said they were already getting 3.2 million, and there's this great quote at the end which I really respect from this judge, and he's done it a couple of times now in a couple of different cases. He says basically, you were just a cohort of independent, self-sufficient 50 and 60-year-olds just wanting more of the pie of your parents, notwithstanding that the parents have made a conscious decision that you already had enough. It just sums it up so well, I think. So I guess the point I'm trying to get to is, yes, your wishes do still matter. The courts still make some sensible decisions out there. I hope it's not a free-for-all. Certainly if you read the Courier Mail, you might think that, or if you follow Steve on LinkedIn, he puts up some great decisions that you could be forgiven for coming to that conclusion. But if you keep your estate planning up to date, make sure it covers all of your circumstances. Don't keep that secret love child away from your lawyer. We kind of do need to know about it. It's it's an awkward question, but we need to know. But if we cover off on all of that and your wishes are written down, you're less likely to be caught in these challenges. So.